So a doctor's office just ghosts your lawyer, and you're sitting there wondering if your medical records fell into a black hole. It happens more than you think, and no, it does not mean your case is dead on arrival. Providers stall for a bunch of boring reasons that have nothing to do with your injury. Sometimes it is understaffed medical records departments, sometimes it is unpaid bills, and sometimes it is just plain old bureaucratic slowness that would make a sloth look like Usain Bolt. Here's the part nobody explains well. Under HIPAA, you actually have a legal right to your own medical records, and a valid authorization signed by you turns your lawyer into your official messenger for getting them. Most offices are supposed to respond within 30 days. That is federal law, not a suggestion, even though some clinics treat it like a polite ask they can ignore. So what does your lawyer actually do when a provider goes quiet? First move is almost always a follow-up letter, calm and boring, just restating the request and the deadline that already passed. If that gets ignored too, lawyers escalate to something called a subpoena. Think of it as a legally binding permission slip that says records must be handed over, and this time silence is not an option. Sometimes the holdup is money, because providers want payment before releasing anything. Lawyers usually negotiate a reasonable copying fee instead of paying some inflated ransom for paperwork. There's also a sneaky reason offices resist, and it is not evil, just human. Some providers worry that releasing records could somehow implicate them if treatment choices get questioned later. That is where a firm records request letter matters, spelling out exactly what is needed and why it is protected activity under the law. Clarity tends to calm nervous administrators faster than vague threats ever could. If the delay drags on, lawyers can file what is called a motion to compel with the court. That basically tells a judge, hey, we tried the nice way, now we need a nudge with actual consequences. Judges do not love wasting time on paperwork fights. A court order usually gets records moving within days, because nobody wants to explain to a judge why a fax machine broke for 6 months straight. Meanwhile, your case does not just freeze in place waiting. Lawyers often work with the records they already have, building the claim while chasing the missing pieces in parallel. This is the part people misunderstand the most. A resistant provider is not the same as a weak case. It is just an administrative pothole, not a dead end. The real lesson here is patience paired with pressure. Good lawyers do not panic. They escalate methodically, using deadlines, subpoenas, and courts-like tools in a very unglamorous toolbox. So next time you hear your case is delayed because of records, you will know exactly what is happening behind the curtain. Want to learn more about how this works? Check out our links in the description.